All right, the court will call the next case, State of Florida versus Brian Scott Thomas. We'll wait a minute for the spectators to leave, Mr. Height. All right, sir, you may proceed.
Okay. Good morning. May it please the court. My name is Wesley Height, and I represent the state in this appeal. This is a state appeal in which the trial court declared the statute that was being used by the state below as unconstitutional facially for lack of mens rea. This was on the heels of the Atkins-Shelton line of cases with the drug cases, and the trial defense attorney submitted that without a mens rea that the statute would be unconstitutional. The state's position it is not, and has filed the instant appeal. When you look at the facts of the case, and just a very limited reference to those, the defendant was arrested for resisting without violence. He was found with 35 personal and corporate checks in his vehicle. He had some blank check stock, both open and unopened. He had a color printer, and he had the routing numbers that had been taken from other people with their credit card numbers. So based upon that, the state charged the statute 831-28-2A, which makes it unlawful to counterfeit a payment instrument with the intent to defraud a financial institution, account holder, or other person or organization, and the part that became relevant below, or for a person to have any counterfeit.
Can this court interpret the statute, the second? I understand your argument about the construction of the statute, that the first part modifies the second part. I'm not sure I agree with you about that, but let's just assume for the sake of argument that we conclude that the second part of the statute does not contain an intent element.
Okay.
Can we interpret it in that way to avoid the constitutional dilemma?
It's the state's position that this court can interpret it that way and should interpret it that way.
Do you have any authority for that proposition?
Well, the statutory authority that we cited throughout the brief that talks in terms of reading it in context. When you look at the statute, this specific statute is one sentence and has the intent with intent to defraud at the introduction of that entire sentence. And admittedly, if it were better drafted overall, we probably wouldn't be here.
It isn't like the federal statute, because the federal statute has the intent to defraud on both parts, right?
It has a knowing element on the second part, but in those instances, there were cases in which cited in the state's brief.
But if we conclude that the statute on its face is unambiguous and that the second part does not include the intent element, are we privileged to read that into the statute, or would that be a violation of our oath and our duty?
Well, any interpretation that is consistent with the statute itself, with the entire chapter, I think there's not only privilege, I think there's an obligation to maintain the constitutionality. There are several cases, several of which are cited in our brief, in which the court reads in an intent element, and that's all the state's asked below. It's all the state's asking here is take that intent to defraud. Cases cited that say use your common sense, don't reach an absurd conclusion, must be construed in its entirety and as a whole. The Cole case cited to this court. When you read those cases, they talk in terms of put it in context of what the legislature intended, and yes, that's exactly what we do. Is a statute is presumptively constitutional if a fair reading of that statute would maintain its constitutionality, and having a general intent to defraud in this instance would be consistent with the state cites several of the chapters of 831, intent to defraud, the defraud intent by the defendant, and that would be exactly consistent with what the state's requesting in this case. When you read the statute, again, it's one simple sentence, and the defendant in this case, it's counterfeiting a payment with the intent to defraud or possession. The argument below initially was possession's a strict liability. And while the state's position is strict liability doesn't make it per se unconstitutional, this particular statute is a general intent crime with an intent to defraud. And when you look at
Is there anything inherent about the appearance of a counterfeit payment instrument that should put one on notice, a reasonable person on notice, that it's contraband?
Unlike illicit drugs and some of the other offenses in which possession in and of themselves would be would have legal uses. The defense cites cases that talk about spearfishing or possession of a screwdriver, possession not being simply enough. Again, that's why the state's position is that this is a general intent crime in which you have to have some evidence, and
Maybe a counterfeit payment instrument could look to an ordinary person could look completely legitimate, right?
A counterfeit instrument, if it's a good counterfeit instrument, could look completely legitimate.
I mean, in this particular case, the fellow had a machine and he had 35-something, and, maybe you can prove intent circumstantially, but just in the abstract, I could be holding a check that somebody tendered to me and given them goods for it, for example, and in fact, it could be a counterfeit payment instrument, and I may be guilty of a crime.
And think how broadly the trial court's ruling is below. He's declaring a portion of the statute to be facially unconstitutional. There is no scenario, and this is not a First Amendment type instance, he's saying there's no scenario the state and its police power can regulate this action, and it's the state's position that ruling is too broad. He did not liberally construe the statute to maintain its constitutionality, and
Mr. Hyde, talk to me a little bit more about that, because to be honest, as I read the statute, where it says that it is unlawful for a person to have any counterfeit payment instrument in such person's possession, I can't envision a circumstance under which such a statute could be constitutional.
if in a strict liability sense, when you look at the Sayez case cited by the defense, having an embossing machine which would have legitimate purposes and could have illegal purposes, the Florida Supreme Court found it violated substantive due process. In this instance, when you have an intent to defraud, which we have evidence of, we have him having prior record of doing similar things, we have the previously mentioned facts with the 35 checks and the routing numbers, et cetera.
The construction argument fails if we just look at the statute. I mean, you said that the judge's ruling was too broad because the judge rejected your statutory construction argument.
Well, we argued below that it's a general...
Look at the statute. I can't imagine how it could be constitutional.
Well, it's unlawful to...
Excuse me. If you read the statute as I read the statute, which excludes the intent to defraud.
Well, and I don't think it excludes. With the it's unlawful to counterfeit with the intent to defraud, and then that following section, and with the intent to defraud for a person to counterfeit. If it was better written, we wouldn't be here. All the other statutory...
It's our duty to rewrite the statute.
It's not your duty to rewrite, but it's your duty to interpret, to maintain constitutionality if possible. All the cases that we have that's cited by both sides that deal with statutory interpretation, if the statute was better written, we wouldn't have an appeal most likely. Let me take a comma and move it around on this statute, and I can clarify it a lot more quickly, and that was a debate below. There were 2 hearings on this. I mean, the defense's argument is based upon the fact that this is not the best written statute ever, but if the requirement upon a court is to interpret it to maintain a constitutionality, and there's case after case that says that. We presume the statute's unconstitutional. If we look at the statute and we see the fact that possession alone is insufficient, if you take out that intent element, the state's simply saying this is one sentence, and when you interpret this one sentence in its entire flow, intent to defraud is part of that, and that's consistent with not only this section, but with every other chapter in that entire counterfeiting fraud statute. There's an intent element, a general intent element that would be consistent with our request of how to interpret the statute.
Well, I think that you could, there's case law that would allow us to read in a knowledge requirement. But then even if you do that, even if you have a requirement that someone knowingly possess these instruments, it can still, though, somebody, for an example, teachers that are teaching kids how to write out a check and have like basically a blank fake check to kind of teach kids in school how to write out a check. And they know they've got that fake check there. They know that it's got probably, fake numbers on it just to make it look real so that kids can learn how to write checks. And that would be purely innocent behavior. So even if we were to read in a knowledge requirement in that portion of the statute that criminalizes the possession of these items, could it also, make what is innocent conduct criminal? It would be criminal then for the teacher to then be.
Well, the legislature considered the concerns in subsection C, which has not been challenged. This section does not apply to law enforcement agencies that produce or display counterfeit payment instruments for investigative or educational purposes. So
The teacher's certainly not a law enforcement
the teacher's not, but I'm not saying knowing possession, we're saying that consistent with the statute is an intent to defraud. When you look at the federal statute, even though it's worded a little differently, as pointed out by Judge Torpy, when you look at the federal statute, people tried to prosecute, federal prosecutors.
Well, it's worded significantly different.
Well, but they still tried to prosecute possession, and the federal court said, even though it's worded better, the prosecutors still tried to prosecute possession, and they said, no, you have to have that intent to defraud, which is consistent with the way the statute is written, consistent with the knowledge, the mens rea element that's in that statute, and consistent with why we're asking you to interpret this statute. If it's okay with the court, I'll use the remainder of my 4 minutes for rebuttal.
Thank you.
Good morning, Your Honors. May it please the Court. Steve Gosney, representing Mr. Thomas in this narrow case involving whether or not this statute is unconstitutional as written. And I would suggest that it is clear and unambiguous and well-written if the intent of the legislature was to eliminate the intent requirement within the statute, which looks to me, when I read this, I don't think it's ambiguous, so I don't think you ever get to the statutory construction issues. The second point I wanted to bring up was that the court had, I think it was Judge Torpy's first question was, does this court have the power to write in to the statute something to make it better or more what the state would like you to do? And I would point you in direction two different things. One is Johnson v. State, which is this court in 2000, when construing a statute, the court may not invade the province of the legislature or add words that would change the plain meaning of the statute. And I think to add in these intent things would be invading the province of the legislature, and that echoes what was the Supreme Court said in Adkins very recently. That is, enacting laws, especially criminal laws, is quintessentially a legislative function. So I think both those are telling this court that it's a very activist thing to do, to come in and say, well, we're going to write in a knowledge element here, when the court's job here is to interpret the statute as it's written. It's clearly written, and it eliminates a mens rea element. Now the question then becomes, is one required? And I think when you analyze the cases, and Adkins is a very poll-star case, and obviously at our office, and I know this court dealt with all the string of Adkins cases and all the mess that caused because of all the people that were subject to the trafficking statute. But if you read that case, the reasons that Adkins upheld the trafficking statutes, when you compare it to this statute, are exactly the reasons that this statute is constitutional. I think I said, the reason that this statute is unconstitutional. And that is that Adkins said, first of all, legislatively, the legislature had specifically directed in Adkins that the trafficking statute was constitutional because the legislature was expressing intent to overrule certain court decisions, and they specified that in this. That was number one. Number two is that the Adkins decision, within the text of the Adkins decision, the statute expressly excluded from criminal liability individuals who have a prescription and other holders in due course of prescription drugs who would normally handle those things and would be exempt from criminal liability. In this case, there is no such statutory exceptions. For example, bank tellers, anybody who's, any businessman who's accepting a check in payment, that person would be held strictly liable for possession of a counterfeit check, whether or not they had knowledge. And the third thing I would note is that the knowledge element of a check, a counterfeit check is a little bit unique from some of these other things in that they're explicitly designed to fool and deceive. So an innocent holder of a check, we're saying a lot of these statutes that sound, well, a person should know that a machine gun or an explosive device or a block of cocaine is illicit and should know that there are laws to apply to that. Whereas a check is something that everybody uses every day.
Let me ask you about Atkins before you get off of that. I'm looking at Atkins and the Atkins court in describing the holding in the Ciccone versus State case said, in Ciccone versus State, this court addressed whether Section 983.13 should be interpreted to include a mens rea, that is, a guilty mind element. In reviewing a conviction for possession of cocaine, this court determined that guilty knowledge was one of the elements of possession of a controlled substance, that the state was required to prove that Ciccone knew he possessed the substance and knew of the illicit nature of the substance or possession. Now, the Supreme Court did that in Ciccone. Why can't we do that in this case?
Well,
The statute's no different than it is here. It was devoid of any mens rea element, and the Supreme Court just infused it into the statute.
okay, let me see. I'm trying to catch up with where you are here.
Oh, I was reading from page 415 of State against Atkins.
Well, again, this allows for an affirmative defense of knowledge. If read subsection 3 there in the Ciccone, the other thing about Adkins is that it did provide an affirmative defense of lack of...
The statute was revised by the legislature after Ciccone, and Atkins addresses the revised statute that has the affirmative defense part in it. But pre-Ciccone, the statute was just it just said it's against the law to possess this controlled substance, and it didn't have any knowledge or guilty knowledge or mens rea element in it. And the Ciccone court, when faced with that, read it into the statute, an otherwise unambiguous statute. So my question is, why can't we just do that here?
Well, obviously the powers of the court here are, we have a divided system of government where the legislature writes the law, and the courts start to interpret the law. It seems to me that to engage in writing, I mean, I would have a lot of questions. Well, what type of intent are we implying here? Are we saying knowledge of the actual possession of the check?
How about we just do it like the Supreme Court did and say that guilty knowledge, that being knowledge of possession of the object and knowledge of its unlawful nature is sufficient, and we just interpret the second part of the statute to include that. That would certainly survive constitutional attack if we did that, right?
Well, I'm not sure, Your Honors. You're the experts as whether that would survive or not. I think the question is what is the right thing for this court to do as a court and not as a legislative body, but as a court and dealt with it, I think an unambiguous statute that does not contain a mens rea element. if it was ambiguous, and I guess we're jumping a few steps ahead, because the next question would be, is it required to have a mens rea element? And if we say that, yes, it is required, and I think that we're kind of in agreement that it does, if you're saying that it does not have one on its face. The second question is, does it require a mens rea element? And I think that everybody's kind of in agreement, yes, it is. Now we're kind of bending over backwards to find out ways, well, how can we make it or say something that it does not say? I would note that it
Well,
does.
didn't the Supreme Court do that in Chicoine? I mean,
Well, I think that we're a step beyond that in
is
Adkins.
that an authority for us to do that here?
There's a lot of authority out there. I think that what we're looking at is Adkins.
Abide by what the Supreme Court does, you know what I mean?
Well, that's why I think Adkins should be followed. Adkins, that's cited in Adkins, and there's a series of steps that went through. Part of the reason the trafficking statute was so problematic is
Well,
because...
in Atkins, they upheld the statute.
Right, they did uphold, but for the reasons that I said, for the reasons that they upheld it, are the reasons that are not in
And in
existence here.
Chicoine, a statute like the one we're dealing with, they said that it has to have this element in order to be constitutional, and they sent, in Chicoine, they sent the case back for a new trial on the statute and required the state to prove that element.
Well,
How is that distinguishable from this case?
well, and again, okay, I think we're taking several steps to where how do we get from here to there? This is it's a different situation in that we have a clear and unambiguous statute. How do we get from here to there? Is the mens rea present? No. Is it required? Yes. May it be inferred? I think if you read Lambert and, Giorgetti, the progeny of that's a sex offender case, the knowledge of the sex offender requirement, that it cannot be inferred under those cases.
Well, let's see, I'm with you on the first two steps, all right? Should
Right.
it be required? Yes. So we're there now. Now the question is, can I infer it? And it seems to me that this Chicoine case tells me that I can, and I'm inviting you to explain to me why under Chicoine I can't, we can't.
And if we do, is it still unconstitutional for some other reason? Or is that the end of it?
Well, I think it's invading the providence of the legislature under Adkins. I mean, I think Adkins, when I read Adkins, I understand your point, but I think when you read Adkins, that type of, we're basically writing into the statute what we want it to say rather than what it actually says.
Well, there's some other cases as well. There's the Siplin case, which is out of this court, which cited the Giorgetti case, which was a Florida Supreme Court case that said guilty knowledge or mens rea was a necessary element of proof of every crime at common law, and therefore it can be presumed that the legislature also intends to include a guilty knowledge element in its criminal statutes, absent an express statement to the contrary. So if there's case law out there that says that this precise thing, that we can infer guilty knowledge into a criminal statute because it's presumed that that's what the legislature intends, that there's an element of proof in every crime, then why can't we do that here in this case and say that it, knowingly possess? And then if that is a valid interpretation that someone can be convicted of a third-degree felony for knowingly possessing this type of instrument, is it, even with that interpretation, is it unconstitutional for some other reason? Or does the analysis stop there?
Well, if this court is suggesting that what y'all should do is write in to the statute, say, a knowledge element, my first thing would be that's the province of the legislature. The legislature's job is to write the law, the courts are to interpret the law. That would not be interpretation, that would be writing.
I'm with you there
Okay.
on your argument, but say that we have the authority to do it, we do it, is it still unconstitutional?
Well, I think what we do is we're running into a lot of problems. By doing that, we run into a lot of problems that are better avoided. For example, when you start writing which elements of this crime are we applying the knowledge to? For example, illicit possession, there are some cases when you're in a trial type situation, that, okay, I have knowledge, that person has knowledge that they accepted that check. Is the knowledge go to the acceptance of the check and the possession of the check itself? Or does the knowledge go to the illicit nature of the check? So, and then what is the level of the knowledge? Is it a specific intent? Is it a general intent? Or is there some other type of intent here that we're applying there? And what level of specificity? I mean, there's a lot of questions that are going to keep coming up
Well,
when
the
we start
statute-
making up our ideas of how it should be written. That's a legislative function to determine that.
The statute says, or for, and I'm just reading the part that,
Sure.
the second part, or for a person to have any counterfeit payment instrument in such person's possession. So what I'm asking you is, or for, if the statute read, or for a person to knowingly have any counterfeit payment instrument in such person's possession.
Well,
If that, if the statute said, if we were to put in, that there is a mens rea requirement of knowledge, that a person has a counterfeit payment instrument in such person's possession, would that, let me ask it another way, because I thought it was a friendly question.
I just started to say,
It's a friendly question.
I'm with
It's a
it.
friendly question.
Well,
Would that make a crime, innocent conduct, still make innocent conduct a crime?
Well, I think it would, because you'd be saying that you have knowledge that you have the check. The question is knowledge of the illicit nature. What would I mean, we could come up with ways, well, how would you draft it, and how would you draft it? I don't think that is the right role for the
Well,
court.
guilty knowledge is what the Supreme Court said in,
Well, and all the other statutes say knowing the same to be false. That's the language that they use in Molden. I think the counsel for the appellant wrote all these things about where it had been used, and they said knowing the same to be false, where it's purposely left out of this statute. So I don't want to, walk on the friendly question.
how do you want me to amend the statute? What did you say?
You're right. No, I don't think that's the role of the court. And I think that I'll reserve the balance of my 30 seconds. Thank you, Your Honor.
Thank you, counsel.
Again, it's a judicial requirement to maintain the constitutionality of a statute. That's what the Supreme Court did in Chacon, and that's what the state's simply asking the court.
I'm not sure that the facial constitutionality was the issue on appeal. I can't really tell from reading that what the issue on appeal was.
Well, I think that...
It seems to be a jury
I was
instruction.
about to say, if memory serves, it's more of a jury instruction, which is the point I was going to make actually at the end of this. When you're getting into the details of exactly what the wording of a statute means and how you're requiring a jury to look at it, I could read you statute after statute after statute and stand here and have a discussion about exactly what the legislature meant.
The question is, how do we know that the legislature didn't intend for this to be strict liability?
Well, I think
Maybe they did. They did in the drug statute.
But they also built in, and this was passed the same time as the response to Chacon. This is a 2001 statute, and I looked through the legislative history, and there was really none of any benefit. And I looked through the Senate bill and the House bills, and when you look at those, I mean, they really don't say what the exact purpose was, except to punish counterfeiting. Consistent with the entire chapter, and consistent with that, is that intent to defraud.
Apparently, the legislature in the drug statute intended for it to be strict liability from the very outset. They just didn't do a very good job of writing it the first time around, and the second time around, they improved it, and it passed muster. But apparently, they intended that from the very beginning. How do we know that that's not what they intended here?
Well, I think the legislature, and it's dangerous sometimes speaking for the legislature because you're talking about an entire body ensemble, but the drug statute was a general intent offense with an affirmative defense. A general intent offense with an affirmative defense. And in this instance, you have a general intent crime. The state has the burden of proving the intent to defraud. If we don't, it was interesting below watching the defense attorney and the state attorney discuss this, and at some point, the defense attorney says something along the lines of, if it's a general intent crime without a statutory affirmative defense, it's unconstitutional. So even he got wrapped kind of around a wheel that kind of made my head spin for a second. Of course, it's not unconstitutional because it doesn't have a statutory affirmative defense, which would be akin to part of the Atkins argument that you're seeing. The state has a mental element. The state has a mens rea, a general intent. If we don't prove it, then the jury would come back and find him not guilty. We have all kind of circumstantial evidence to prove it in this instance. We're simply asking, consistent with maintaining the constitutionality of a statute, to have that knowing, guilty knowledge element, which would be consistent with the intent to defraud. Chacon did it. There's numerous cases cited in our brief that do it, and that is consistent with this, the question's asked a couple of times, can the judiciary do it? There's case law that says not only can they do it, they're required to maintain the constitutionality if what the state would submit is a fair reading of that statute would have an intent element. That's all we're asking, is to be consistent with that sentence, with that statute, with that entire chapter, and to maintain the constitutionality. So, thank you.
All right, thank you. Thank you, counsel.
Can I have my 30 seconds? If I have 1
Wait.
second.